Hello, welcome to AC 1.1 of Unit 4. So as we move into Year 13, some new PowerPoints, updated 2025, which will take you through the rest of the course. So starting with AC 1.1, which is entitled Describe Processes Used for Lawmaking. So let's delve into this. So what this AC is asking is, who makes the law in England and Wales? And actually the answer to that is there are two main ways in which a law is created. The most common way is through government, through Parliament, through an Act of Parliament. There we go, an Act of Parliament. Or it's made by the judiciary, by judges. And we'll look at these in detail as we go through this PowerPoint. So it's either government by an act or by judges, and I'll explain that in a little more detail in a minute. So let's start by looking at the government, the parliamentary process. The vast majority of our laws are made by passing what are called Acts of Parliament. So other phrases you might hear, laws made by Parliament are also known as statutes, they're also known as legislation. So worth knowing the terminology. Now, within our Parliament, because it's called the Houses of Parliament, there are actually three parts to it. We've got the House of Commons, there they are, current Prime Minister Keir Starmer at the time of doing this PowerPoint. We've got the House of Lords, there they are. House of Commons has green leather seats, House of Lords has red leather seats, and you have the monarch, the king or the queen. There is Prince Charles, and as you can see, there is the House of Lords, there is the throne which he sits, which is actually in the House of Lords. Now it's important to know what role each of these plays within our law-making system. So let's start with the House of Commons, and what I'm going to do before I get into this is just do a brief introduction of each of the houses, because I often find that students don't really understand who makes up the House of Commons, who makes up the House of Lords. So I'm going to do some very brief description of it. So the House of Commons is made up of 650 members who are called Members of Parliament, MPs. They represent a constituency. They're elected at general elections, which have to be held every 5 years. And you have the Prime Minister, who then makes a cabinet. These are the top jobs within the politics, such as Chancellor of the Exchequer, Foreign Secretary, Education Secretary, Health Secretary, Home Secretary, etc. You'd have the opposition, opposition sit on this side of the House, and then the government is the political party that's in power. They're the ones that hold the majority of the seats, which at the moment is the Labour Party, which sit on this side of the House. On the other side of the House, we've got Conservatives, Lib Dems, Reform, Plaid Cymru, Scottish Nationalists, Irish parties, etc., etc. And all Parliament is the name we give to all 650 MPs. Government is the name we give to the MPs that are in the party that hold the majority. So currently we have a Labour government. We still have 650 members of Parliament. So what's the role of the House of Commons? Well, it is to make policy, to make laws, to decide how to run the country. They will debate matters of general concern or current concerns. At the moment, they'll be debating stuff on Gaza, Ukraine, etc. They'll scrutinise and vote on laws proposed by the government. The opposition will challenge the government, hold it to account through rigorous questioning. And they are meant to represent the views of the electorate. So if you've elected a local MP and you don't think your MP is doing what you want them to do, you have the opportunity to vote for someone differently at the next general election. They are meant to represent your views. When it comes to the House of Lords, slightly different. That's currently got 829 members. They're unelected, they're unpaid, and attendance is voluntary at the moment. It's made up of hereditary peers. That's gradually being phased out, but there are 92 left. It's made up of life peers who are awarded for a contribution to society. That's not hereditary. and it's made up of 26 bishops of the Church of England. Now, hereditary peers is basically because your father was a lord, when he dies, you take over his place in the House of Commons. So the membership of the House of Lords passes down through the family just because you happen to be a lord or an earl or a duke of somewhere. Life peers are appointed by the government, and they are for the duration of your lifetime. And this is why the membership fluctuates, because if a life peer dies, they're not necessarily automatically replaced. And some governments will appoint more life peers than others. And then there's the 26 bishops of the Church of England. So to give you an idea, here is a member of the House of Lords, Lord Aberdare. His full title is Alistair John Lyndhurst Bruce, and he is a member of the House of Lords because his father, Lord Aberdare, and his grandfather, Lord Aberdare, when they died, they passed on the title to him, and with the title comes membership of the House of Lords. Then you've got this man here, Lord Cameron of Chipping Norton, the Right Honourable David Cameron, David William Donald Cameron, ex-Tory MP. When he resigned, gave up standing as the leader of the Conservative Party, gave up as Prime Minister, he was given a place in the House of Lords as a lifetime peer. Then you've got this lady here, Baroness Grey Thompson, full title, Baroness Grey Thompson DBE. She was our most successful wheelchair athlete. She's won the London Marathon loads of times, loads of Paralympic gold medals, and she has been appointed a lifetime peer for her contribution to disabled sport. Then we have this lovely lady here, Baroness Benjamin. She's one of my faves, only because she was known as Fluella Benjamin, or is known as Fluella Benjamin, and when I was a kid, she was one of the presenters of the children's programme Play School and Play Away. So she was a TV presenter, does lots of good work in the community, and she's been appointed as a peer as well. And then lastly, you got another example I've chosen, Lord Archbishop of York, and he's in there because he's Archbishop of York. So you can see the breakdown of the House of Lords. So what's the role of the House of Lords? Well, they complement the House of Commons. They can scrutinise and amend legislation. They can question the government. They can debate policy issues and matters of general concern. They can introduce some bills, so they have the power to introduce laws, and they can delay legislation to allow further time to research and consult. And one of the reasons why many years ago we were trying to get Brexit through, Theresa May was trying to get the Brexit bill through, the House of Lords is one of the places where she couldn't get it through, and it kept being moved back for amendments, etc. The House of Lords delayed that legislation. And finally we get to the King, and his role is basically, it's just a formal role. He accepts the resignation of the Prime Minister and appoints a Prime Minister. He can't refuse it, he just has to do it. He formally agrees new laws by signing them. This is called royal assent. So a law doesn't become a law until the King has signed it. He can't refuse to do so. And here's a lovely example of how our country works. So when the Queen was alive, Liz Truss was appointed Prime Minister, but then she didn't do a very good job, and so she had to resign. So consequently, Queen was up in Balmoral in Scotland. So Liz Truss had to get a. Sorry, I'm talking rubbish. This is when Boris Johnson got resigned. Boris resigns, Liz takes over. So Liz Truss travels to Balmoral and no, let's get this the right way around, Phil. Right. Boris Johnson resigns as Prime Minister, so he gets on a plane, flies from London up to Scotland to see the Queen and says, can I have your permission to resign as Prime Minister? She says yes, so he flies back down to London. Then Liz Truss gets on a plane, flies from London up to Scotland, goes to the Queen and says, please can I have your permission to form a government? Queen says yes. And then 46 days later, Liz Truss is kicked out, so off she goes again to the Queen. Oh no, by then the Queen's died, so she has to go to King Charles and say, I want to resign. He has to say yes, and then Rishi Sunak comes in, and so on and so forth. Bonkers, but there we go. So, that's how Parliament's made up. Let's get back to the process by which a law is made. So the questions you usually get are describe how the parliamentary or government process for making a law. So it's worth knowing these stages. So first of all, know the right terms. A bill is the name for the proposal as it moves through Parliament. So every law starts as a bill, and then after it's come out of Parliament, it becomes a statute, a legislation, law, whatever you want to call it. Okay. An act is when it's been approved by Parliament and given royal assent. So an act is a law, a bill is not yet a law, it's just moving through Parliament. So let's look at the process. So before any new law or change to a law goes to Parliament, it usually starts with a green paper. And this is a consultation stage where the aim is to allow people both inside and outside of Parliament to give feedback on the policy they're proposing, or the legislation they're proposing, or the change in legislation they're proposing. And it's coloured green, it's called a green paper, hence its name. Once that consultation process has ended and they start to firm up some of the ideas, it's then formally put down as a formal proposal, and that's called a white paper. Now, sometimes they won't go to the green paper stage, they go straight to the white paper stage when they need to move things quickly, or they don't feel they need consultation. But before going to Parliament, it's green paper, then white paper, or sometimes just white paper. But for the purposes of answering an exam question, start with green, then white, and know what each stage means. So you have the discussion, policy document is the white paper, and then it moves on to, the green paper, then it moves on to the white paper. Okay, it's, public meetings, debate in the media, that sort of thing. The government then makes the decision whether or not to introduce the bill. You can have many bills that get to this, start off here and never go through Parliament at all. But let's assume it's now going through Parliament. We now move on to the parliamentary stage. So the lawyers draft the bill, compose some wording, and through to Parliament we go. So the key thing to remember here is that the bill will go through exactly the same set of stages in both the House of Lords and the House of Commons. So it has to go through exactly the same stage twice, both in the House of Commons and in the House of Lords. And a bill can start in the House of Commons and finish in the House of Lords, or start in the House of Lords and finish in the House of Commons. It doesn't matter which one it starts in, but it has to go through both houses. So, whichever one it starts in, it will start with a first reading. That is the formal introduction of the bill. The clerk reads the name of the bill. There's no debate or discussion about its contents. It's just, we're going to bring in this legislation. So a formal presentation of the bill, only the title's read out and the MPs that are sponsoring it. We then go through to the second reading, and that is the first time the bill's debated. That's when MPs decide whether they should pass it on to the next stage. That's when they start to vote on whether it should go on. So your second reading is the general principles of the bill are debated rather than its details. It's the principles behind it. We then move on to the committee stage, and that's where they start to get into the nitty-gritty. A committee of MPs go through the bill in detail, add amendments that may have been suggested. Most bills are considered by what's called the Public Bill Committee, usually made up of 17 MPs, and bills can also be considered by a committee of the whole House, but that's very rare indeed. So the committee stage is a select committee or a committee of the whole House where it's debated in detail, each clause is agreed, amended, deleted, etc. But that's not done by all 650 MPs, it's done by groups of 17 MPs, which reflect the makeup of the Houses of Parliament. There'll be lots of different committees making lots of different bills. It's part of the work of an MP. Once it's been through the committee stage, it goes to the report stage. And that's where the whole House considers what's been done during the committee stage. And amendments can then also be proposed at this stage. So the report stage, it's been amended and then members have a chance to agree or disagree with what the committees have come up with. Then it moves to its third reading, and that is the final opportunity for members of Parliament to pass or reject the bill. Usually there's an hour of debate or so with that. So the third reading is considering any amendments that have happened, but they can't change anything in the third reading. After that, it goes to the other house. So if it started in the House of Commons, it goes to the House of Lords, and both houses have to agree. If they don't agree, bill gets moved back again, and that's called ping-ponging, where bills fly between the two houses until they agree. That's what happened with Brexit. It ping-ponged all over the place. So if it starts in the House of Lords, goes to the House of Commons, it'll be first reading, second reading, committee stage, third reading, etc. All that stuff has to be done. Once that has happened in both the House of Lords and the House of Commons, it then moves to royal assent. So the monarch has to formally agree, signs the bill, and then it becomes an act of Parliament. The law can come into effect immediately, or it can come into effect after a set period. That's up to the government to decide. So for ways of making it a bit easier, you can think of it this way. If it starts in the House of Commons, first reading, second reading, committee report stage, third reading, and then goes to the House of Lords, first, second, committee report, third reading, any amendments, royal assent, and then it will go there. And if it starts in the House of Lords, exactly the same process. If you click on that website, it will give you some examples of bills that are coming through Parliament as we speak, and they use this graphic here to show the stages of the bill. So you can look at those at your leisure. So that's the parliamentary process. The next is judges making law. And I'm going to use this opportunity to talk about the role of a judge. It's part of a later AC, but it fits in, I think, slightly better here, so I'm going to use it here. So you often get questions, describe the role of a judge. So this is it. I just use the bits in that have been highlighted in yellow. That will make it easy for you. So judges, completely independent of police and government, can't be told what to do, can't have their decisions changed by ministers. The only way that you can appeal a judge's decision is go to a higher court of appeal. Now, I'll be talking about appeals and high courts of appeal when I look at the judiciary in the criminal justice system. But just so you know, the highest court of the land is the Supreme Court. Once the Supreme Court's rejected your appeal, you're not going any further. You've got to accept the decision. So, laws are created by Parliament, by the process of first readings, second readings, committee, etc. But it's the job of the judge to make sure that people are punished if they break those laws. They have to uphold those laws. So, judges are usually very experienced barristers and solicitors. Just the precise level of experience required to be a judge varies, but you can be pretty certain that you don't become a judge after a couple of years in the legal profession. You've got to be a long time at it before you will be made a judge. And the judges use their knowledge and experience of the law to make sure that a trial is conducted in a fair and legal way. Okay? And the roles played by judges are different in each type of legal court. So, if we take a Crown Court judge, which is where most judges will sit in the Crown Court, this is the role. Crown Courts, where the most serious criminal cases are heard by a judge and guilt is decided by a jury. So, in a Crown Court, the judge makes decisions about the law and manages the trial. It's the jury that considers the evidence, and it's the jury that considers and makes the decision as to whether a person on trial is guilty or innocent. In our country, your guilt is always decided by your peers. In a magistrate's court, it's magistrates who are members of the public, not legally qualified, and in a Crown Court, it's jury who are members of the public, not legally qualified. In cases where a jury has found the defendant guilty, it's the judge who issues the sentence. And throughout the trial, it's the judge that's got to make sure the jury is aware of its legal role, in other words, what it should and shouldn't do, advise them on legal issues, so the court case stays within the law. At the same time, judges can also apply what's called common law. And this is law that's grown out of decisions by judges in court cases over decades and even centuries. And I'm going to go into this in a bit more detail because this is how judges actually make law. But first of all, let's just remember that any decision made by judges in a court, High Court, Crown Court, Supreme Court, whatever, Court of Appeal, they're recorded. And if you are a judge in a lower court, you use those decisions to help you make your own ruling in your court cases. So what that means is court cases aren't treated randomly, and punishments for the same sort of crime are similar and fair wherever they happen. So I go out tonight, drink 10 pints of beer, steal a car, involved in a police chase, and run over a member of the public and kill them. I can be expected to spend quite a bit of time in prison, probably guilty of causing death by dangerous driving, which carries a maximum of a life sentence. I can be pretty sure that if I do that, probably am going to get a life sentence, and you would expect if somebody else did exactly the same thing somewhere else in the country, and they would get exactly the same sentence as me. If they didn't, then justice is not fair. So it's about judges making sure that they're abiding by previous cases. So this is how judges make laws. So they use it, there's two ways they can do it, and there's two long phrases you just got to remember. Judicial precedent, which I'm going to deal with first of all, and then statutory interpretation. Judicial precedent is what I've been talking about for the last couple of minutes. So it's a source of lawmaking where you take the past decisions made by judges, and those decisions are effectively creating laws for future judges to follow, which means that where there's a point of law in a case today, it has to be the same as in a previous similar case, because the judge must follow the decision made in the previous one to make sure that justice is fair for all. Therefore, we're consistent, therefore we're fair. So judges follow those previous decisions using the court hierarchy, with the Supreme Court at the top and the magistrate courts at the bottom. So the way it works, a decision made in the Supreme Court has to be followed by all the courts below, the Court of Appeal, the High Court, the Crown Court, the Magistrates Court. Likewise, if a decision made in the Court of Appeal, it's got to be consistently followed by those below it. So it's got a higher precedent, if that makes sense. So once a decision's been made there, all other courts have to follow and go with that decision and be the same. So let's go through it. If there isn't a precedent, then judges' decisions will form the original precedent, which means that they're creating law which all other judges then have to follow in the future. And the example that's used in the textbook of this is the case of Donoghue versus Stevenson, and I would learn this one. So in Donoghue versus Stevenson of 1932, this was a landmark case in negligence law. If you go to university and you study law, you're going to be doing this case, I guarantee it. Now, nothing like this had ever happened before, and it was a landmark case because it established the principle of duty of care for manufacturers and consumers, even in the absence of a contract. So it's often referred to as the snail in a bottle case, and it involved a consumer who became ill after drinking ginger beer, which was found to contain, this bottle of ginger beer was found to contain a decomposing snail in it. Now, Mrs. Donoghue, who had consumed the ginger beer and became ill, sued the manufacturer, David Stevenson, and she won her case. The judge said, even though you haven't got an official contract with the manufacturer needs to take care to ensure that customers are not getting snails in their ginger beer. So that then established a principle that manufacturers had a duty to take reasonable care to avoid causing foreseeable harm to consumers. Okay? The precedent, the judicial precedent was set. So we move forward 5 years to the case of Daniels versus White. In this case, Daniels sued a lemonade manufacturer, White's, still going today, after experiencing a burning sensation in his mouth from drinking lemonade, because he found that the bottled lemonade contained a corrosive metal. Now, that went to court, and of course the precedent had already been set in Donahue versus Stevenson. Snail in ginger beer, metal in lemonade. Metal's not a snail, ginger beer's not lemonade, but the principle is very similar. So the court's decision in this case is bound by the earlier ruling in Donahue and Stevenson. It's established the principle of a manufacturer's duty of care to consumers. So White has to be guilty, and whatever sentence was imposed on the Donahue versus Stevenson case has to be similar in the Daniels versus White case. Okay, so the ratio decidendi, which just means reason for decision in Latin, requires the court to apply exactly the same principle to the lemonade case. So there are only 2 situations where a court doesn't follow judicial precedents, and that's called distinguishing, and that's where the judge finds the facts in the present case are different enough to the earlier one to allow a different decision and not follow precedent. So trying to think of an example, but if you think about it, we've talked about you're following precedent because snail, and even though it's not the same as metal in snail as metal and ginger beer is not the same as lemonade, actually the case itself is very similar. If the cases are widely different, then you can't apply the precedent. That's what we're saying. And then finally, overruling. Now, if in the original case Donahue Stevenson had complained about the verdict and gone to a court of appeal, and the court of appeal had overturned the decision because it's a higher court, then that decision stands as opposed to the one from a lower court, and that's called an overruling. Pretty straightforward. So let's move on to statutory interpretation. Statutory just means interpretation of a statute, interpretation of a law. Now, as well as setting judicial precedent, judges can make law by the way they interpret the Acts of Parliament, the statutes, the laws. Because laws are written down, judges have to interpret the meaning of the words within the law and apply them to the cases they're judging. Now, they have 3 main interpretation rules to help them to do this. They use the literal rule, the golden rule, and the mischief rule. And I'm going to go through each of these in the next few slides. So let's start with the literal rule. Now, under this rule, judges apply the everyday, ordinary meaning of a words in a statute. Now, the most famous case is the case of Whiteley versus Chappell. And again, this is in the textbook, so you can use this one. Now, the law said, and the exact wording of the law was, in red, it's an offence to impersonate any person entitled to vote at an election. Now, in the case of Whiteley versus Chappell, the defendant was charged with impersonating a dead person who was no longer entitled to vote. So the person had come to and impersonated someone who died and had rocked up at a general election and voted on behalf of a dead person, and was then arrested and charged under the offence of impersonating any person entitled to vote at an election. Now, if you read the wording of the law, this is where the statutory interpretation came in. The court applied the literal meaning of all of these words. So it's an offence to impersonate any person entitled to vote. That is the offence. Now, the defendant's solicitor argued if you've died, you're not entitled to vote. Yeah, the solicitor was correct. Dead people are not entitled to vote. Because the defendant was impersonating a dead person, he was not impersonating someone entitled to vote, because dead people aren't entitled to vote. Therefore, could not be prosecuted under that law, and was therefore found not guilty because a dead person is not entitled to vote. So the literal meaning of the words are taken and applied, and therefore not guilty. Now you may think that's a bit weird, but there are other ways of doing it. And that leads us on to the golden rule. So in the case of that we've just looked at, the literal can lead to a rather absurd result. And the golden rule allows the court to modify the literal meaning to avoid this. So the famous case here is in Adler versus George in 1964. And here the court applied the golden rule to interpret the phrase "in the vicinity of." Now, according to the Official Secrets Act of 1920, here's the offence. It's an offence to obstruct His Majesty's or Her Majesty's forces in the vicinity of a prohibited place. Now, the defendant, Adler, was obstructing an officer within a prohibited place, RF Marum, and he argued, I may be an instructing officer, I may be in a prohibited place, RF Marum, but the law says in the vicinity of a prohibited place. I'm not in the vicinity of, I'm in it. So, and here's where the golden rule works. If you were applying the literal rule, probably he's not guilty because he's not in the vicinity of, he's in it. The court, however, said, oh, don't be so stupid. We're extending the meaning of in the vicinity of to include both in and near the prohibited place. So therefore, he was, otherwise you would get an absurd outcome under a strictly literal interpretation. So there you go, found guilty. And the final one is the mischief rule. And the mischief rule just allows the court to enforce what the intention of the law was, what it was trying to achieve, rather than what the words actually say. So the court case here was Corkery versus Carpenter, and here's where they applied the mischief rule. So under the Licensing Act of 1872, you weren't allowed to be, in the words in red, drunk in charge of a carriage on a public highway. There's no mention of the word bicycle, and of course Corkery was drunk in charge of a bicycle. He argued a bicycle's not a carriage, therefore you can't prosecute me. And the court went, yeah, that's not what the Act's really on about. The whole purpose of this is to stop drunk people creating a danger to the rider and to others, and therefore the mischief, the causing danger to the rider and causing danger to others, is what the Act is trying to prevent, and therefore we're going to find you guilty. Simple as. So that is that. Hopefully you've got an understanding of how laws are made in this country. You know the law process under government, and then statutory interpretation and judicial precedent. Hope you've enjoyed that. I found it informative, and I shall see you soon for some more presentations. Take care, have a good day, goodbye.